Call to order the Colerain Township Board of Zoning Appeals meeting for Wednesday, September 24th, 2014. Welcome to the meeting, and we're going to begin with the Pledge of Allegiance. So if you would stand and join me. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. We'll begin with the statement of procedures for this evening's activities. Sequence of events is as follows. Appeals will be heard first. Other business of the board will be heard following the appeals. You're welcome to stay for the entire meeting, but are not required to do so. All who speak or testify before the board will be sworn in. This may be done either as a group or individually. Anyone addressing the board is requested to use the speaker stand. Each person is asked to give his or her name and address when first testifying. Other meetings are recorded. Anyone speaking may be cross-examined by an attorney. All documents presented for each case may be accepted by the board. The chairman will rule whether additional items being offered will be accepted or rejected. The person presenting each case may also withdraw a document. Each case heard will first be presented by a staff member, usually the zoning administrator. And once the BZA staff presentation is completed, the appellant will have the opportunity to present their case. Following the appellant's presentation, the chairman will ask for anyone opposed to the appeal to speak. In some instances, time limits may be placed on presentations. Next, the board will motion to close the public portion of the hearing. Then individual board members will begin with their questions. Board members will ask individuals who have testified to return to the speaker's podium. Following the board's questions, a motion and second will be made by members of the board to either approve or deny the appeal. It is important to note that this vote is called a straw vote. This vote brings forth the resolution at next month's meeting, and that's the final order of the board. Finally, respect for this process and one another is paramount. Deliberations in each case are taken seriously by this board. Likewise, it is the expectation that respect will be accorded to everyone regardless of any emotion that may be involved, and no disruptive behavior will be tolerated. And this extends to all who testified as well as members of the audience, and anyone being disruptive will be asked to leave the hearing room. So we'll begin with a roll call, please.
Mr. Bartolt?
Here.
Mr. Martin?
Here.
Mr. Price? Mr. Roberto?
Here.
Mr. Reininger?
Here. All right. Anyone who is going to testify this evening, I will ask to stand and raise your right hand. Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth in matters before the Board of Zoning Appeals? Say, I do. Thank you. All right, let's begin with our, I'm going to ask for a change of the sequence of hearings tonight. I'm going to move BZA 2014-23, a variance for accessory structure first. Do we need a motion to do that? Yeah.
I don't think so.
Okay. So we'll, if the zoning administrator would start with BZA 2014-23, we'll do that first.
Very good. Okay, so this is a case that was continued from last month. It's located at 3350 Melody Manor. The applicant. Well, let's start here. My office received a complaint about an above-ground pool and deck that was constructed 6 inches from a property line. Upon investigation, it turned out that no zoning certificates had been issued for the deck, the pool, or an accessory shed. Officer Frandoni inspected the property in June and found the property to be in violation of the zoning resolution. June 25th, the owner applied for a zoning certificate for the deck and pool, but I was unable to grant the zoning certificate because the attached deck and pool were shown to be in the side yard setback. So actually it was the deck that was in the side yard setback. So on July 11th, the applicant applied for a variance, and it was heard in August last month. At the last meeting, we heard testimony from the owner that suggested that the deck was constructed prior to the adoption of the new zoning resolution in 2006. The board continued the case till tonight to allow the applicant to provide evidence of that fact. The applicant has since provided sworn testimony that in the form of a letter that the deck was constructed in early August of 2006. So just to refresh your memory, this is the site, this is the pool, this is the deck, and here is the accessory shed. It's all R6. And in terms of findings of fact, I found that a pool, a deck, and an accessory shed were constructed on the subject property without a zoning certificate. The deck was constructed within the required 5-foot setback. However, at the time of construction, the setback was only 3 feet. Given the zoning regulations that were in effect at the time of construction, the variance requested is not substantial. It's only a 24-inch variance. The property in question would likely yield a reasonable return without the variance because other homes in the R6 district are able to yield reasonable returns with decks that are constructed outside of the setback. The owner's predicament could have been obviated by reconstructing the deck outside of the 5-foot setback. However, in this instance, requiring the owner to do so would present practical difficulties to the owner. The variance would not adversely affect the delivery of government services. The essential character of the neighborhood is typified by homes that conform to setbacks prescribed in the zoning resolution. The illegal construction of the pool with a deck inside the prescribed setbacks does negatively impact the essential character of the neighborhood, but not to the extent that it would justify mandating the removal of the deck. If the adjacent property owner had suffered a great detriment, as their initial complaint implied, they likely would have been present at the August hearing to oppose the granting of the variance. No neighbors were present. I received no correspondence from anyone. I haven't received any correspondence from anyone since the initial complaint was made. So there was no opposition aside from that initial complaint to granting the variance. There are no unique characteristics of the parcel that would support granting the variance. It is, for all intents and purposes, a regular lot. There was some testimony, however, that there is some topography on the east side of the site that would make it more difficult to reconstruct the deck on the east side of the pool. Whether the owner knew about the zoning regulations when they purchased the property is unclear. By taking into consideration the benefit to the applicant if the variance is granted, weighing that against the detriment to the health, safety, and welfare of the neighborhood and broader community, I find that substantial justice would be done by granting the variance, and I recommend approval.
Thank you. The applicant here.
Hey, my name is Nick Vogel.
Address?
Yes.
Your address?
Oh, 3350 Melody Manor.
Thank you. Comments you would like to make, sir?
Well, as he stated, I hope to have worked everything out with him when I met with him upon getting all the proper permits to get everything stated. We explained everything and went over everything as far as what we could do. All that I'm asking is for the variance to be left, for the deck to be left, because all it is the 3-foot back section of the corner that's actually over the 3-foot property, the line of where we were going by 3 foot from the property line at the time. It was basically the back corner. I had a little template, I should have brought it with me, but it's basically about 1 foot out by 3 foot long. It's just the back little corner, as you can see in that picture. The deck's on an angle, and we set it up that way originally because when you walk out of the back main deck off the house and you walk down, it's right there, and it's right, it's real nice. And the other side there was a hill and stuff like that, and I didn't think my neighbor would appreciate me and constructed a huge deck over there on the hill where he could have to look up and look at it the whole time. We did it, and we figured it was out of the way since it was adjoining the neighbors. The back end of their property where nobody ever goes. It's all overgrown bushes half the time and weeds and and nothing. All the neighborhood kids play in the pool. I don't know who would have even called and why they would have called. I mean, there's no reason. I talked to all my neighbors and none of them had any clue as to what was going on. So it's really kind of puzzling to me. It's kind of weird. So I think the original complaint was for the pool actually being too close to the property line originally, but the pool was actually built 5 foot out, and I should have gotten. I was under the assumption that the installer of the pool got the permits for that, and I should have checked on that. I just assumed he went ahead and did that, but I should have taken care of it. So I'm asking that the deck be left as the way it is, if it can be, for the variance. But like I said, when we constructed it, we were under the assumption it was 3 foot, and we knew that corner was going to be real iffy because of the way it was set up and all that. But we thought hopefully this isn't going to be a problem because, like I said, it's right at the back of the corner of a lot that nobody ever sees. That so that's basically where I'm at.
Very good. If that includes what comments you wish to make, then we'll just go through the protocols, ask for anyone who's opposed to this request to speak. Anyone else? There is no one opposed. I'll ask for the public portion to be closed.
Make the motion. I'll second.
Motion's been made and seconded. Might as well stay there. And questions from the board are next. So, Roberto?
If you were forced to rebuild the deck, how much do you think it would cost for you to rebuild the deck to the right side of the sloped? I know all the difficulties and impracticalities of it, but I mean, in a roundabout number.
I would say probably anywhere from $2,000 to $3,000, roughly, assuming, but by going by lumber costs and stuff like that, and labor costs and whatnot.
Okay. And then obviously you would have to have a building permit to do that.
Right. Right.
Have it done most likely professionally.
Right.
I'm thinking you're being conservative, but
Right.
that's really all the questions I have.
Okay. Mr. Martin?
I wasn't here last month, so I kind of had to get up to speed a little bit, but I just had a couple of quick questions. I think everyone on the board is trying to come up with a good faith argument to support your variance, but I need a couple more facts in order to do that. First of all, do we know, is everything else okay? I mean, is the fencing okay? I mean, I know that there are certain height limits for, 4 feet for above-ground pools. Are all the other zoning requirements okay and met on the property?
There's a 4-foot fence with a gate that latches, right?
Mm-hmm. Well,
Yeah, that's what I recalled also. And there is, the deck is in the setback. The deck, the pool, and an accessory shed do not have zoning certificates.
Okay.
Pinpointing the moment that those were constructed is difficult.
Right, but you had the pool constructed though, right? You didn't buy the house with the pool there?
no, yeah, I had to put in.
And you had a commercial installer?
Mm-hmm.
And you signed a contract with them?
Yeah, I guess so. Yeah.
'Cause usually a contract will say that they're responsible, you'll pay for it, but they're
Right.
responsible for getting all the permits.
Right.
You don't know if you did that.
Well, no, it's the pool company. They have outside like I signed the deal. I bought the pool from the company, and then
What company?
called the Pool Spa Warehouse on Reading Road.
Okay,
And they basically have outside contractors that they use. They don't have contractors themselves. They
Right.
have a list of different people they go, and basically it's who's available to get to come out. So it's usually a guy that does it on his spare time, on the side with his, I think this guy 3 or 4 kids with him and stuff like that. That
but
construct.
the one, the Reading Road outfit is the one that should have, you have a contract with them, and it should say, normally it would say,
Right.
that they're responsible for getting the contracts, or the permits, but you don't know if that's the case?
Honestly, I don't know. No, I don't know. Man.
Okay, because that would be something if it had been last month, and I know we need to move along on this, but if it had been last month, I would have probably asked you to try to dig out that contract or contact them and see, because I think frankly, not to give you legal advice, but to give you friendly advice, I think, whatever you've spent here, you could certainly call them and ask them for, the time limit may have passed, but it seems like they dropped the ball here.
Yeah.
And caused this problem. The other question I have for you is, how come after 8 years, the neighbors also, all of a sudden, do you know which neighbor it is that complained?
I have an idea. The only reason I can think of is because the lady's a little loopy. She it's got some issues. Like I said, her grandson swims in our pool all the time with my son,
Right.
and all his buddies do and stuff like that. She's had some problems with a neighbor next to her, an older lady, that over dogs and stuff like that. That's the only person I can honestly think of, because all the kids, she says she didn't call when I asked her about it, but I asked all the neighbors around and talked to everybody, and nobody really even knew anything about it. That's the only person I could suspect, because that's the only lot that it butts up to is right there. And I don't know why she would do it now. There's no reason. Like I said, like you said, it's been there for 8 years, so
Right.
there's no reason to. I don't know if she just, honestly, I don't know. I really wish I knew.
Well, it is what it is.
Yeah.
Unfortunately, I think you're kind of caught in the middle here, and it would be rather difficult and expensive to change it. So, I guess I'm persuaded.
Oh, appreciate it. Thank you.
Barthold?
I don't have any more questions. Fine.
I don't have any questions, so I will ask for a motion to approve or deny the request for variance.
I will make a motion to approve the variance.
I'll second it.
Motion's been made and seconded to approve the variance. Roll call vote, please.
Could we include in that motion that we're including the staff findings as the,
Certainly.
yeah, thanks.
With the staff
Yeah.
findings
Thanks.
included.
And maybe just a quick question from, do you think is it worthwhile to contact, a letter to this pool company saying, hey, be aware of the fact that you put this pool in without getting a permit and you need to do that in the future?
We could certainly do that. It was
I
8
don't
years
want
ago.
to add to your workload, but.
Yeah, no, I mean, we could do that. Unscrupulous contractors are not welcome.
Right. I just think it might send the right message so that it doesn't happen again.
Thank you.
Motion's been made with the
Will you make a second?
amendment.
And I'll second,
seconded
yes.
With the amendment?
amendment.
Okay. Then we'll do a roll call vote.
Okay, Mr. Bartolt,
Yes.
Mr. Martin,
Yes.
Mr. Roberto,
Yes.
Mr. Reininger.
Aye. Very good. Okay, variance is granted. Thank you.
Thank you.
We have one member absent for our meeting this evening, and our substitute is here, Mr. Kelly. So if would please the board to have Mr. Kelly sit in and let the record reflect he will participate in the next hearing. All right, so this case is BZA 2014-05. It's abandoned sign, article/section 15.6.11, continuation from the July 23rd, 2014 meeting. Location is 10140 Colerain Avenue. Applicant owner Louis Zettler Jr. And their staff presentation, please.
Thank you, Mr. Chairman. This appeal is an appeal on behalf of Mr. Louis Zettler, who owns the property. I believe he has counsel present this evening to represent him. The location of the property is 10140 Colerain. Back in March 4th, we issued a notice of violation for an abandoned sign on the property. We issued a final notice on April 24th, and the applicant has appealed the interpretation and/or the application of the zoning resolution to the sign on this subject property. The case was actually originally scheduled for May. It was continued to July, and then at the July meeting, Mr. Barrett, on behalf of Mr. Zettler, suggested that the owner was in negotiations, I believe, with ODOT or one of their contractors to remove the sign structure. And Mr. Barrett requested that the matter be tabled until this meeting to allow negotiations to be completed with either ODOT or their contractor to help remove the sign. So I believe that because this case has been continued so many times, that the findings of fact have remained the same since the beginning. I'll save you that reiteration of those findings of fact. They're included in your packets. But just to remind you where we're talking about, this is 275 here. This is the subject property. We have the butcher shop here and Lowe's off to the right here, the big Walmart complex back here. So the property is zoned B2. These are images. On the left side of the screen, we'll see an image from 2006, which shows right here, this is the sign structure. And this is the shadow of the sign structure, which demonstrates that there was no sign on top of the sign structure in at least 2006. So it's been abandoned for quite some time. This is a picture from, I believe, March, and this was a picture from, I believe, April. Just so we know what we're talking about. You can notice the deteriorated condition of the sign here, which is one of the reasons why we're so interested in getting this thing down. Staff findings were included in your packets, and just to reiterate, the staff recommendation is to deny the appeal and require the owner to remove the sign.
Thank you. Is there anyone here to speak in this hearing?
Thank you.
Chairman, I don't think he was sworn.
That's right. Yeah, that's where I'm going. Now, if you do wish to address it, the protocol is that you have to be sworn in.
I'm an attorney at law. I don't believe attorneys are to be sworn in when they're representing clients before administrative bodies.
Correct. Okay, that's fine. Thank you.
For the record, C. Francis Barrett with law firm of Barrett and Weber, and my address is 500 4th and Walnut Center, 105 East 4th Street, Cincinnati, Ohio, 45202. I represent the property owner, Louis Zettler Jr., trustee. As was indicated, the subject property is at 10140 Colerain Avenue in the B2 district. And when I was before you in July, indicated that we wanted to see if we could get the contractor for ODOT to give us a proposal for removing the sign. Subsequently, through contact with the Ohio Attorney General's office, which is representing ODOT in the highway road widening project, I was informed the contractor is J.R. Jurgensen Company. I spoke with the J.R. Jurgensen Company and requested that we get an estimate for the cost of the removal of the sign. And I was informed that would be something they would look into. And I spoke with Mr. Scott Solman, your attorney, this morning. I actually left him a voicemail message yesterday in my efforts to get an estimate, because I had not received one as yet. I've been pressing them recently, and I've been out of the office most of the afternoon, but I did receive an email that I understand indicates that they have concluded that because of the size and complexity of the sign, they don't have the ability to remove it. They recommended a contractor from Columbus who apparently has expertise in removing cellular towers. Unfortunately, we do not have an estimate from them. Initially, they'd asked me about whether it would be demolished and then preserved for scrap, or demolished and simply removed. They told me the former was more difficult, so I agreed to do it in the latter form, where there was no scrap. Yet even under those circumstances, they've now concluded that the project is too much for them. So I will proceed to make efforts to contact this company in Columbus and see if they have the ability to do it. Mr. Mills mentioned to me today that, or actually just before the meeting started, he and Mr. Solman approached me, indicated that there was some contractor that allegedly talked to our client and is prepared to make an estimate. I've not received that. Interestingly, I did talk to Mr. Zettler this afternoon. He is out of town, he's out of state, but he didn't mention anything to me about that, and I think he would have if he had received it. So I can only assume as of this point in time he has not received it, but I'd be happy to follow through with Mr. Mills and get that information. As Mr. Solman pointed out, it appeared to be reasonable. So I intend to follow through in that regard.
Okay, we are in a different uncharted waters. I will close the public component of this hearing, and then we'll just go back and forth with board questions.
You may want to ask if there's anyone here that is in opposition to the proposal.
Thank you, Mr. Berg. Is there anyone here to speak in
Or in favor and opposition?
favor
Yeah.
or in opposition to this request?
Thanks.
Hearing and seeing none, I'll ask for a motion to close the public portion of this hearing.
Make the motion.
I'll second.
Motion's been made and seconded. All in favor?
Aye.
Okay, now we'll begin with board questions, and we'll start with Mr. Roberto.
Well, it sounds like we're going to tear it down. We're going to deny it, so it's going to get tore down based upon his feedback, right? I mean, I'm kind of confused here because from all the indications that he just spoke, it's being tore down.
Well, this started in March, and so what has happened through the appeals process is the applicant has gained more time to get the job done, but the job still isn't done.
Okay.
The next step is to deny the appeal,
Okay.
I would say, and then now
And
there's
set a
clarity
time
as
limit.
to the fact that you agree that this is an abandoned sign. our zoning resolution prohibits abandoned signs. The sign needs to come down. The appeal is denied. Therefore, the applicant must bring the sign down. That way there's no,
I really have no questions.
Sure.
And I'm ready to go on.
Mr. Martin?
Well, I'm in a conundrum here, because if I do this correctly, everyone's going to be mad at me, I guess, but it's nothing new. I'm not at all impressed with the progress that's been made since Mr. Barrett was here the last time, when he assured us that we would come to some resolution at this meeting. That was 2 months ago. I wasn't impressed 2 months ago because I thought things had progressed a lot further than they had, apparently. So in that sense, I'm really not inclined to cut any slack to them. On the other hand, going back to last spring, part of the reason that I joined or applied and was accepted, I guess, onto the zoning board was that Colerain Avenue, to me, is a nightmare. The signage on Colerain Avenue is a nightmare. And in the year and a half or so that I've been on the zoning board, this is the first appeal of an actual enforcement action. And as Mr. Mills knows, and other people may know, there was a bit of a dust-up last spring when I asked for an update on the zoning enforcement actions on signage on Colerain Avenue. And the reason I believe and still believe that that is in my official capacity to ask that question is not because this board directs the enforcement action or has anything to say about the enforcement action, but when we are dealing with an appeal of an enforcement action, it seems to me it's incumbent upon the board to know what other actions are being taken on Colerain Avenue. Because as ugly as this sign is, there are many, many, many more egregious examples of abandoned signs up and down Colerain Avenue. And I've repeatedly asked, not because it's in my purview to interfere with enforcement actions, but repeatedly asked, where are we? And I'll give you a couple examples. LA Sound. That LA Sound, I've been in town 4 years now, and LA Sound closed way, way, way before I moved here. And that sign, I pass by that sign every day. The other sign that bugs the you-know-what out of me, and I do live on the, let's say, the less attractive end of Colerain Avenue, but the old, is it Builder's Square? It's been gone so long, I don't even know what used to be there, but that sign is uglier by 10 than this sign. So the last time I asked, I was told that we were taking enforcement action against those people, that notices were issued, and that we were about to go to court. So again, I ask now, where are we on those other enforcement actions? Because, and I'll tell you the reason I need to know that as a board member, not because I want to interfere, but this applicant, although they've dragged their feet, in my humble opinion, did the right thing. When they got a notice of violation, they appealed it. If notices of violations were issued to LA Sound and to the old Builder's Square, and the sign I know that annoys you, Jeff, the one going, by the post office sign there, if notices of violation were issued to them and they didn't appeal them, and the town has done nothing to enforce them, then we're not applying, in my opinion, equal protection and due process to this applicant. So again, I'm in a conundrum here because I really do want to enforce the zoning regulations on the signage on Colerain Avenue, but I don't think it's fair to enforce it here if we're not enforcing it elsewhere.
yes, I've heard that argument made on this floor before, and I've answered that argument a number of times. We
well, not by me, I don't think.
Yeah, we have taken quite a bit of enforcement action on Colerain Avenue. There are all the signs that you mentioned are in violation and have been issued notices of violation. The fact that the owners have not appealed those violations indicates to me that they have forfeited their opportunity to appeal at this point because the final notice has been issued and 21 days is come and gone. So we are working with Mr. Solomon and the housing court to address those issues.
Have we actually filed something with the housing court on this?
We have taken steps. The housing court, we're currently in the process, even though we have pursued previous action in housing court, pursuant to Judge Mock, who is the judge of the housing court in County Union. We're in the process now of having them adopt Colerain's regulations and enforcement codes, whereas prior to that, they were they were reclassifying them as Hamilton County violations, even though that wasn't the proper code, so we're in the process now, even though we just recently got some actions we're trying to pursue given back to us, and we're told as recently as of this afternoon that we need to have a resolution adopted by the court that accepts officially the zoning enforcement of Colerain Township. And we'll be in the process, obviously, of following that up. But we have obviously pursued at least 20 plus actions. I don't know how many of those actions are related to signs specific.
Well, I mean, Joseph Chevrolet, for example, I mean, the banner signs, I don't think they're allowed, are they, Jeff?
No, and we actually just had, I can, I know that you don't like to believe me, but I can assure
Oh, I do. I believe
I can
you, but-
assure you that I work very, very hard on bringing signs down, and all the issues that you're raising are important ones, and they're important to me too. And that's why I work so hard to get these down. And we can talk about all of the successes that we've had on bringing signs down on Colerain Avenue. We could talk about all of the failures that we've had up to this point bringing signs down. None of that would be germane to this case, and the reason it would not be germane to this case, and I would just ask rhetorically, if you were a judge and somebody got a speeding ticket and the speeder said, I would like records of every speeding ticket that was issued on Colerain Avenue to demonstrate that there isn't fair and due process, that argument doesn't hold any water. This is absolutely, this case is one that is related to the property at 10140 Colerain. It is in violation of our zoning resolution, period. Everything else is parenthetical, and I'm happy to address those things parenthetically, and I believe that we just did. So,
well, let me reply quickly. Number one, you'd be mistaken again, and I've said this before, to take this personally, because no one is suggesting you don't work hard. Number two, the example you gave is an interesting example because, as you well know from reading the newspaper, there have been towns that have been taken to court because people have asked for information about how many speeding tickets have been issued in a particular area or how many red light violations have been issued because there's an equal protection issue. And it is absolutely, and I guess I don't question you, I take issue with what you said. My question is absolutely germane here because, again, I have some hesitancy because I don't think that the applicant has done everything they could here. Mm-hmm. On the other hand, this applicant, in my humble opinion, there's an argument to be made that they are really being disadvantaged because they did the right thing. They appealed their violation, whereas the LA Sound people, the Building Square people, or whoever they are, the Joseph Chevrolet people, have just sat on their hands, apparently knowing full well that by sitting on their hands, nothing's going to happen to them.
Well, you would be wrong.
Well,
because something is happening to them, and you would be wrong for advancing that because something is happening.
Are we at a point where we're discussing protocols versus the case in hand? I think the points have been made, but I really want to come back to looking at what we're dealing with.
And I think that's very appropriate, especially given the fact that Ohio case law has held that Board of Zoning Appeals, it's not their job. You talk about equal protection.
Right.
Those are constitutional issues, and constitutionality is not within the scope of your decision-making process pursuant to Ohio statutes.
Absolutely, but equal treatment, I try to treat everyone here equally, and no one is going to tell me that I'm not allowed to treat people equally. And I want to make sure that this applicant is not being treated unequally because they did the right thing by appealing.
You can, I guess at this point in time, you can only take my word or not take my word. Right. This applicant is being treated equally, period.
All right.
Okay, I'll leave that up to Mr. Barrett to decide, I guess.
All right, so let's, Mr. Barthold, questions?
Just one more time, is there a new deadline to wrap this up?
So once the application is denied, once the appeal is denied, then it would be journalized next month. That would be an extra 30 days. And then once we have a journalized resolution that says that it's denied, then we would take the next appropriate legal steps to enforce our zoning resolution, as we would with any case that came before us.
Or in that time, they can take the sign.
Exactly.
Or agree, or not agree, but decide not to. Right?
Ideally, that would be the best bet.
Yeah. And we don't know. Well, not we, but you're like you said, you're still getting prices to dismantle. that correct?
Yes,
Come to the podium, please.
I have been advised, we looked at this, the best way to do it, after talking to the attorney in the Ohio Attorney General's office, the transportation section, who's representing ODOT, what he said to me was, you know, if we had appropriated your entire site, as you know, they're widening, ODOT's widening Colerain Avenue,
Someday.
and that's the point I was going to get to. They're taking right-of-way, plus they're taking a temporary construction easement on this property. The temporary construction easement will be for like 2 years, then it'll go back to the owner. But what he had said to me was if ODOT had made this a total take, then we would have taken the sign down. So he said, what I recommend to you is that when the contractor comes out to do the work, that you talk to them about taking the sign down at your expense as opposed to our expense. Part of the delay was the contract had never been let with ODOT. It since has been let with the J.R. Jurgensen Company. Now today, I don't know. I tried to find out when the actual work is going to start, and I don't know. But apart from that, I asked J.R. Jurgensen to give me an estimate as to what it would cost to take it down. I didn't know when they were going to take it down because they probably wouldn't have done it until they did the work, and we don't know now when they're going to do the work. But then they told me, after I pressed them end of last week and beginning of this week, they came back and said to me it's too complicated. So they gave me a name of a company in Columbus, which I'm not familiar with, which takes down cell towers. So as we stand here right now, I don't know. I apologize, but I can't give you any dates.
Okay. I was just curious. I mean, whether it has to be a company from Columbus, anybody with a large crane, put them up and they can probably take them down.
That's why we thought that the Jurgensen Company could do that.
Yeah.
I mean, I didn't understand how they could take it down if they had taken the whole site. They
Yeah.
couldn't take it down if they didn't take the whole site. I didn't understand that.
So if Jurgensen gives them a reasonable price and they accept it, but then the work doesn't actually happen until next spring because winter's coming, I guess we would be okay with waiting till spring?
It would, at that point, you know, once it's denied and we have clarity that this structure needs to come down, you know, then we would move through our enforcement process, and that would include, you know, the outcome that I want is the sign comes down, right? The outcome that isn't optimal is we spend a lot of time and resources in court talking about the sign coming down until the sign comes down, you know? So my personal philosophy is to, with every option that I have, every opportunity that I have, to work with applicants to get the sign down. But the case before you guys tonight is, was my interpretation of the zoning resolution correct? And was the application, you know, was it fairly applied? So.
Okay, no further questions.
What I was concerned about was that if you did deny our case, then to protect my client, I'd have to appeal, and then it gets into the court system and so forth and so on. And again, I know you don't feel very strongly that our position has any merit to it, but if we did have to be denied, I want the opportunity to have a hearing and present our evidence just to protect myself. But if you turn us down, I'm concerned that I have to appeal to protect my client from being cited for not complying with an order. That's why we filed an appeal initially, so we'd have time to work this out without being in violation, because if we'd ignored it and the time had run, clearly you would have had the right to enforce it.
After September 20, after the October BZA meeting, that's when the clock starts ticking for your client to appeal that to Court of Confidential, right? And do you know the time period off the top of your head of?
30 days
30
from
days.
the date you actually journalize a written resolution.
So now we're into the end of at the end of November before you would have to file an appeal to our journalized resolution. And
When
I
is
would
your
ima-
meeting in October? The fourth
Wednesday.
fourth Wednesday of
Yeah.
October.
And so you would have basically till the fourth Wednesday of, roughly the fourth Wednesday of November before you would have to file anything in courts. That would be 2 months from today to get a contract in place. And with a contract in place, that's good enough. That's good for me.
Thank you. Thank you.
Thank you. Mr. Kelly, do you?
I have, do they have the ability, the financial ability to get this done? I mean, are they figuring something's maybe going to cost $10,000?
That was a major concern, how expensive it was going to be. I didn't know how expensive it was going to be. My client was very concerned it was going to be prohibitively expensive.
Okay.
But if there's any merit to what Mr. Solomon told me before the meeting, that seemed, I thought, fairly reasonable, the number he quoted me. I don't want to put that on the record because I haven't seen it.
Yeah, Yeah.
I just plucked that out of the air. I didn't hear that. But is that the kind of number you're hearing?
No.
No, it would be.
I thought it was going to be more than that, but what number he had is actually less than that.
Okay. And is that something that your client can afford?
I will call him. He's out of town right now, but I'll find out. Our concern was how expensive it was going to be, and I was relieved to hear Mr. Mills mentioned.
What I'm wondering is this the appeals and this whole process? Are they doing this to buy time because they don't have the resources available to get this?
No. If say for example a number were $100,000, then it'd be worth his while to appeal it to court. If it's kind of number that they're talking about, it wouldn't be.
Okay.
It would make economic sense to take it down.
Okay.
That's kind of off the record, but I wanted to answer your question.
Sure.
Thank you. That's all.
Thanks.
Okay, the chair does not have any questions, so at this point I'll ask for a motion to either deny the appeal or approve the appeal.
I will make a motion to deny the appeal,
I'll second.
based upon also with the staff finding.
Okay,
And I'll second that.
motion's been made and seconded to deny the appeal. Any other discussion?
Is there anything that we can add so maybe their attorney doesn't have to come back so often, because it does seem like this has got to go through several channels to make things happen. Is there anything that we can do to make this easier?
Once we take an action and approve this, then it's in a protocol. It's in a sequence of steps.
So we
pretty much
can't
fine.
add time to it or anything like
Well,
that?
it would, no, not really. Right. But it wouldn't have to come back to you guys. You guys would be done. Yep.
That's it.
All right, roll call vote, please.
Mr. Bartold,
That's a yes to deny, right?
yes to deny.
Yes.
Mr. Martin,
For all the reasons stated, I'll abstain.
Mr. Price, Mr. Price isn't here. Mr. Kelly on behalf of Mr. Price.
I vote yes. to
Mr.
deny.
Roberto,
Yes.
Mr. Reininger.
Aye.
Thank you.
The motion is, appeal has been denied. Moving on to the next item, resolutions for adoption. The first resolution for adoption, BZA 2006-26, amendment to condition 7, which limits the size of vehicles. The location is 8510 Cog Hill, Cincinnati, Ohio. The applicant is Eric Schmidt / Joan Lurman, and the owner is Joan Lurman, trustee. Okay, whereas Eric Schmidt and Joan Lurman on April 23rd, 2014, filed an application with Colerain Township Board of Zoning Appeals requesting an amendment to Condition 7 of Resolution BCA 2006-26 as applied to the property located at 8510 Cog Hill, Colerain Township, Hamilton County. Whereas Article/Section 11.8 empowers this board to permit the substitution of a non-conforming use existing at the time of enactment of this resolution in compliance with Article 11. And whereas this board has considered all evidence properly presented and finds that amending Condition 7 of BZA 2006-26 as requested by the applicant would result in more than merely minimal adverse impact on the adjacent properties and surrounding neighborhoods and not be in spirit of the zoning resolution, therefore be it resolved, and I'll read the entire condition here, that by virtue of the foregoing, the Colerain Township Board of Zoning Appeals does hereby modify Condition 7 of the zoning resolution BZA 2006-26 as follows. The owners and occupants shall not store or operate the types of vehicles or cause the types of vehicles to be operated upon the premises which are larger than the size of pickup trucks as defined by this board to constitute vehicles such as those depicted as Vehicle 7 in the attachment to the staff's presentation. This motor vehicle limitation is intended to restrict the size of the commercial motor vehicles which access the property operated by the owners or occupants of 8510 Cog Hill Lane, as well as the size of commercial motor vehicles of any business associates / entities conducting business with the owners or occupants of 8510 Cog Hill Lane, with the following exceptions. Trash and sanitation vehicles used for removal of trash and septic waste generated on the premises, vehicles used for snow and ice removal on the premises, fire and public safety vehicles, parcel delivery trucks, and public utility vehicles operated by individuals other than the owners or occupants. Owners or occupants include agents, servants, employees, and subcontractors of the owners or occupants. Okay. So we need a vote to grant the modification as just read, and we'll go through our roll call.
Mr. Bartold.
Yes.
Mr. Martin.
I think I'm going to have to abstain because I was not here.
Mr. Price. Mr. Kelly, on behalf of Mr. Price.
No.
Mr. Reininger.
An affirmative vote grants the condition as defining vehicles. Okay, so I will vote aye or yes to grant that condition.
The modification to the, yeah, got it. Mr. Roberto?
Yes.
Very good.
Okay. All right, the next is BZA 2014-19. Whereas Lights and Signs LLC on June 26, 2014 filed appeal number BZA 2014-19 with the Colerain Township Board of Zoning Appeals pursuant to Article 3.3.2 of the zoning resolution seeking a variance is applied to the property located at 8313 Colerain Avenue, Colerain Township, Hamilton County. Whereas the board has considered all evidence properly presented and finds that to deny the variance would not result in unnecessary hardships to the owner of the premises in question and would be in keeping with the spirit of the zoning resolution. Therefore, be it resolved that by virtue of the foregoing, the Colerain Township Board of Zoning Appeals does hereby deny a variance of Articles / Section 15.8.3 bracket G of the zoning resolution. And a roll call vote, please.
Mr. Bartold.
Yes.
Mr. Martin.
Abstain?
Mr. Price. Mr. Kelly for Mr. Price.
Yes.
Mr. Reininger.
Aye.
Mr. Roberto.
Yes.
Move on to number 8 on the agenda, which is unfinished business. I do not have any listed on my agenda. Is there? Okay. And then the next is approval of the minutes, and the board members will note that there is the minutes are at your place with the modification on page 4. First complete paragraph has been edited. This is a modification from the one that was sent to email us.
I will make a motion to approve the minutes as they were written,
I'll second those.
That written in modified.
with the modified, the ones we received today.
Okay, thank you. Motion's been made and seconded. All in favor?
Aye.
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 I'll abstain again.
Okay. Administrative matters.
None.
Motion to adjourn.
So moved.
Second.
Seconded.
Okay, all in favor?
Aye.
Aye.
Good. Administrative matters, Jeff, on that, those workshops coming up.
Yes.
Is that, do we need to give you a heads up on who's? There's a workshop coming up in January, I think. Yeah, do we need to give you our names if we're going to attend, or? Okay. I think Bob was there, Ron was there, yeah. All right.